Right now, thousands of people are walking around with what they think is the end of their asylum dreams, a final denial letter from USCIS. But what most people don't know, and what even most immigration lawyers don't know, is that you can actually apply for asylum again with USCIS even after receiving a final denial. And I'm going to tell you everything you need to know about applying for asylum a second time with USCIS. Here's what we're covering in this deep dive. First, I'll explain exactly who this applies to and what a final denial actually means. Second, we'll talk about why you'd want to apply again and how the process works according to USCIS's own rules. And third, and this is crucial, I'll break down the one-year filing deadline challenge and the exceptions that might help you. Now, fourth, we'll discuss some other important complications or potential complications like children aging out and strategic considerations about who should be the principal applicant. Let's get started. I'm Brian Manning. I spent 11 years working for the government's two main agencies for asylum and refugee matters. I adjudicated thousands of immigration applications during my time with the US government. But now, as an asylum lawyer, well, my law firm helps immigrants all over the country to secure their future in America through asylum. All right, part one. What are we talking about exactly, and who does this apply to? Well, we're talking today about the ability to keep pursuing your asylum case even though you've received what's called a final denial. Not a referral to immigration court, not a notice to appear, but rather a final denial issued by USCIS. Now, let's get clear on who this applies to, on who exactly we're talking about. So we're focusing on people who applied for asylum affirmatively with USCIS, had their asylum interview, and got a negative decision. But here's the key. Instead of putting you in deportation proceedings, USCIS sent you a notice of intent to deny, what we call a NOID for its initials, NOID. You may or may not have responded to that NOID, trying to change their minds. Ultimately, they decided against you and gave you what's called a final denial. This letter basically says, we're not going to give you asylum, but because you have some kind of legal status right now, well, we didn't put you in deportation proceedings. Your case is just over, denied. This typically happens to people who had status like temporary protected status, TPS, or maybe student status, or even tourist status at the time of the decision. Now, because most people who've applied for asylum recently have gotten their interview pretty much right away, many are getting a final denial while they still have their tourist status, which is usually valid for 6 months from entry. So look, people fall into lots of different categories. Some have been here just 2 or 3 months, while others have been here maybe 6, 8, or 10 years or more at the time that they get their asylum interview and negative decision. Many people came on a tourist visa, applied for asylum during their first year, and eventually got temporary protected status. They had their interview while they had TPS, got the NOID, and then the final denial while they still had TPS. Now, the problem with this scenario is that TPS is eventually going to end. It's inherently temporary, as the name indicates. We've seen a lot of litigation around efforts by the Trump administration to strip away TPS, to end it. And this has been the case for people from Afghanistan, Cameroon, Haiti, South Sudan, Honduras, Nicaragua, and Venezuela. It's still not clear how all of this is going to play out. A lot of people are therefore really concerned, understandably, about falling out of status and possibly receiving a notice to appear if their TPS ends. And to be clear, when you get a notice to appear, or an NTA as it's known, it means the government is putting you into deportation proceedings. They're now actively trying to deport you. However, and crucially, having an asylum application pending with USCIS may be a way to avoid being put into deportation proceedings. And so this is one of the reasons why many people who have received a final denial may want to apply for asylum again with USCIS. Having that asylum application pending with USCIS may shield them, at least for a while longer, from receiving an NTA. You see, traditionally, USCIS has not put into deportation proceedings people who have a pending asylum claim with the agency. So, applying for asylum now, including a second time, may be a way to protect yourself. But this, of course, is not the only reason why many people may want to apply for asylum again. Many want to keep pursuing their claim so they can win their asylum case. They fear being harmed in their country, and they want to get long-term protection here in the United States. They want to get asylum, a green card, and then U.S. citizenship. And that takes us to Section 2. yes, you can actually reapply. Here's what USCIS says. So the good news is that yes, and to the great surprise of many people, you can actually apply for asylum again with USCIS even after a final denial. The Affirmative Asylum Procedures Manual, which is the procedural rules that USCIS follows, explicitly says that you can apply again for asylum even after a final denial. At page 222 of the AAPM, it says that someone who has been denied asylum in immigration court cannot apply again for asylum unless they established so-called changed circumstances. But then it goes on to say that actually, prior denial of asylum by an asylum officer does not invoke the prohibition on filing a new asylum application. So if you've been denied by the asylum office, then yeah, you can try again. The AAPM goes on to provide instructions about the processing of these cases, but I've got to be honest with you. It looks like it's going to be pretty hard to win under this circumstance for multiple reasons. First, the AAPM says that they'll try to assign your case to the same officer who interviewed you previously if that's possible. If that officer is still at the office wherever you're applying now, well, they'll try to match you with them. Now think about what this means. You're just getting put back with someone who's already interviewed you, decided against you with the notice of intent to deny, and then decided against you yet again with the final denial, right? So it's going to be really hard to change their mind. Now, even if you get sent to a new officer, there's a very real chance that they might just want to defer to their colleague who previously denied you. Now, there's no formal requirement that they do that, but just, psychologically, there's probably quite a few of them who are going to give a lot of deference to their colleague and, might be reluctant to essentially overturn that colleague's prior decision. The AAPM furthermore says that substantial deference should be accorded to prior determinations made by an asylum officer regarding previously established facts, including credibility findings, unless clear error is present. So what does that mean? Well, it sounds like you probably won't get a chance to tell your entire story again. Rather, it sounds like they may just more or less go off of the story that you recounted in your testimony during your prior asylum interview. Now, in light of this guidance, it's unclear how much you'll be allowed during your second interview to expound and add to what you said, or at least in terms of stuff that happened while you were still back in your country. And if you were found not credible the first time around, well, that distinction is likely going to stick, it seems, according to this guidance. Now, I want to stress that I do think you'll still be fully heard out on anything that's happened subsequent to your prior interview that indicates that you're at risk. Like if there are developments you can point to that indicate that you're still at risk, that will be considered. Moreover, the new officer is meant to do a new legal analysis, which could end up benefiting you. They might just see it different legally in terms of, applying the facts to the law and reaching a conclusion about your asylum eligibility under the law. Also, country conditions could have changed since your prior decision in a way that's helpful to your case now. And hopefully you'll have an asylum lawyer writing a legal brief for you this time around, connecting the dots for you and doing the legal analysis to show exactly how you meet all of the asylum eligibility requirements. So while I don't think it will be easy, I do expect that some people who were previously denied will in fact find success on this second attempt. And that takes us to section 3. The 1-year filing deadline challenge. Yes, we still need to talk about another challenge, and it's one that could be a major hurdle for many people, the 1-year filing deadline. Now, you probably know that to win asylum, you generally need to apply during your first year in the United States. Well, for people who arrived recently and then applied for asylum shortly after arrival and got a quick interview and a quick decision, well, this might not be a problem. Many of those people will be able to get their second asylum application filed within their first year in the country. But for many people, it will be a problem because they've been here for more than a year, and it looks like USCIS is going to use the current filing date, that is, the date of your second application, for purposes of the 1-year filing deadline analysis. Now, I say this because the AAPM says new asylum applications filed by applicants previously denied by an asylum officer are adjudicated according to regular procedures, except for in a couple areas not relevant to the 1-year filing deadline. Now, under regular procedures, the officer considers the issue of the 1-year filing deadline. So I do worry that this is going to be a problem for many people. To be sure, I do think there's an argument to be made that USCIS should use the original filing date from your first application, but the AAPM guidance suggests that they probably won't. This gets us into a really tricky area, and we need to dig a bit deeper now into how the 1-year filing deadline works exactly. You see, there are exceptions to it, circumstances where you could get around it and still win asylum, despite that the operative filing date is coming more than a year after your arrival. Now, there are two main categories of exceptions to the 1-year filing deadline. Number one, the extraordinary circumstances exception, and number two, the changed circumstances exception. Now, the latter, changed circumstances, may apply for some people, like if something has happened really recently within just the last few months before your second filing that puts you at real risk or really escalates the danger to you. But the category that will probably help more people is the extraordinary circumstances exception, because within that, there's a concept called maintenance of status, which says that if you maintain immigration status, well, you can get around the 1-year filing deadline. Now, the clear-cut case where you can benefit from this is if you've had legal status your entire time in the United States through your second filing. So, for example, if you came on a tourist visa and got TPS approved while that tourist visa was still valid, and you still have TPS right now, and you've never done anything to violate your status such that you have been covered by legal status the entire time that you've been here, well then, if you're filing now while you do still have this legal status, you'll definitely be covered by this extraordinary circumstances exception of maintenance of status. So you'll be okay, you'll get around the 1-year filing deadline. What's less clear though is whether you can benefit from this exception if there's been a gap in your status, if it has lapsed at some point. So, for example, maybe there was a period where your TPS ended and you had applied to renew it, but there was a while there where you didn't have valid status before the renewal was approved. You see, USCIS policy isn't really clear on whether you necessarily have to have continuous unbroken status in order to benefit from this extraordinary circumstances exception of maintenance of status. What's also unclear is the impact of having a pending immigration application. Now, some people will come here and apply for asylum while they still have their valid tourist status, but then, they don't have anything else. They never get any other kind of status, or maybe there's a gap before they eventually get TPS status, but all the while, they've had an asylum application pending. The effect of having had an application pending, including an asylum application, is sort of unclear. Guidance that USCIS asylum officers follow says that it's something that should be taken into account in assessing the totality of the circumstances relevant to whether the person might establish an extraordinary circumstances exception to the 1-year filing deadline. But it doesn't technically count as maintenance of status. Basically, it's a gray area, and it's unclear how USCIS will treat cases like this. So, in short, the 1-year filing deadline is a really complicated area of the law, and it's unclear how USCIS will treat your case if you fall in any category other than the one where you have had valid status through the time of your second asylum filing. Therefore, if you've been in the United States more than 1 year at the time that you're considering filing a second asylum application, well, you should definitely talk with an asylum lawyer first. All right, and with that, we're at section 4. Other potential complications to consider. Yes, there's yet another potential complication caused by this issue of the passage of time that we need to consider. Whether your children can still be included as dependents in your case or will instead need to apply on their own as principal applicants. Recall that a child can only be included in your case if they're under 21 years old at the time that you apply. Well, what about families who applied when their children were under 21, then they got a final denial and are now considering applying again, but a child has in the meantime turned 21. Can that child be included as a dependent in the new claim? Well, if USCIS takes the more charitable position that your original filing date is the operative date for your second filing, then yeah, I think they'll consider the child to be sort of grandfathered in. Now, there's an argument that USCIS should do this, and they've actually said that they will do this for cases where someone is applying now with USCIS after having had their case dismissed by an immigration judge. Now, in those cases, USCIS has said they will use your original filing date for purposes of assessing the 1-year filing deadline in your new case, and they'll allow your children to be dependents in your new claim as long as the children were under 21 at the time you originally applied for asylum. So why not take the same approach here, where we're talking about someone applying for asylum with USCIS after a prior final denial by USCIS? I think that's a reasonable argument, but I don't know whether USCIS will buy it. They may say, no, if your kid's now 21 or older, well, they can't be a dependent in your claim, despite that they were under 21 when you originally applied for asylum. Honestly, I think the safest route is probably to double track it, to have your kid apply on their own as a principal applicant if they're now 21 or older, but to also seek to include them as a dependent in your claim, hoping that USCIS will agree to do so. Okay, one more thing in terms of what you should be thinking about before applying again. If you're married, you should assess whether it makes sense for you to apply again as the principal applicant or to instead have your spouse apply now as the principal applicant, with you being a dependent in their case. There are strategic considerations that go into this that need to be considered before proceeding. For instance, maybe your spouse actually had a stronger claim to begin with. Maybe there's been changed circumstances that affect your spouse more directly than they affect you. Or, maybe your spouse is more likely to benefit from the extraordinary circumstances exception of maintenance of status. These are the kinds of things that need to be thought through carefully with an asylum attorney. Okay, finally, section 5, my bottom line assessment. Look, I've given you a lot of information, so let me give you my honest take on all of this. I can't stress this enough. This is a complex area with real consequences. The decision to file a second asylum application after a final denial should not be taken lightly, but for many people, especially those facing the end of TPS, those without other immigration options, well, this may be the best path forward. The key is to work with an experienced asylum attorney who can evaluate your specific situation and help you put together the strongest possible case the second time around. Because here's the reality. If you're going to do this, you need to do it right. You need to address whatever weaknesses existed in your first application, in your first presentation of your case. You need to present new evidence if possible. You need to explain any changed circumstances, and you need to be prepared for an officer who may already be predisposed to deny you. Now that's a tall order, but it's not impossible. Listen, time may be of the essence due to one-year filing deadline complication. You may be in a race against the clock and you might not even realize it. Look, if you're ready to take the next step and get help with your asylum case, then please call my office today. That number is 713-909-0401. And remember, we help people all over the country, so it doesn't matter where you live. Call us now to schedule an asylum strategy session so that we can help you to secure your future in America through asylum. Again, I'm Brian Manning, and it's truly an honor to support you in your asylum journey.